Hi folks, with Tacitus today at your Pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to compare two legal cases that aren't running sort of concurrently, but one's just finished and another's recently started, where on one side there's allegations that somebody interfered with an election which may have cost the Democrat candidates, or candidate in this case, votes. Now, given the overall votes cast, this wouldn't have changed the outcome of the election, not by any stretch. So that's one case. In the other case, there's a lawsuit claiming that the votes were either prevented from being counted or whatever for the Republican candidate, and that the amount of votes in question would have very materially altered the outcome of election by a very substantial amount. So now the laws around, I don't want to go into the minutiae of that sort of here, but the laws around have to really prove two things. One is that it was the intent of the person or persons to affect or alter the natural course of the election outcome. So intent has to be proved. And secondly, that the effect of the interference, and I'll use that term generically, the effect of the interference would have been to alter, or most likely alter, the outcome of the election. So, and those are reasonable laws, I guess. I certainly interfering with the election for the purposes of altering the outcome, whereby the will of the people is not being expressed, and I agree that that is illegal. The whole point of voting in any democratic system, whether you want to call it a republic or something else, it's people voting to decide their government, and that's the material point here. And the will of the people is central to any democratic or voting-based selection of government. And it is very important, I believe, to protect that from any form of interference that in any way dilutes or prevents the will of the people from being expressed. So, and I think any politician of any persuasion, or any judge for that matter, and all laws should be made to protect that expression of the will of the people. Now, so in these two cases, though, where the allegation is that the Democrat candidate is alleged to have suffered loss of votes, again by a very small amount, and nothing that would change anything at all. So no one's arguing that. But the lawsuit, which is being zealously pursued by the federal authorities in this case, the state authorities don't really seem to care, but the federal authorities think it's a big deal. And bear in mind that the Federal Justice Department of the United States at the moment is probably the most partisan Justice Department that you can imagine. I mean, it makes Eric Holder look like a moderate from the Obama days. But the idea in the lawsuit is that the person intended to have an interfering effect, if I can use that phrase, on the election process or the casting of ballots, and that because they had this intent, it therefore is they've committed an offence, or in this case they're arguing a federal offence. So now it's a bit of a stretch, and really when you're stretching things that far, you must be sort of in a lot of doubt as to how well your case is going to go. Now, the accused party believing the case to be quite absurd and really drawing an exceptionally long bow to bring these charges, sought to have the case dismissed in court. Now, I think any judge, applying the law would have, in my view, have dismissed it. and would have treated it with the nonsense value and the nuisance value that it deserved. It's just, I think, in my view, a private citizen is being intimidated just because they're on the wrong side of the political divide, and a very politicized Justice Department is going after them on a partisan basis. That's my view, and I think that's quite blatant. So anyway, so they managed that when the case is heard in court, and it's in they go to have it heard in a very activist district, but of the judges in this particular district of this jurisdiction, there's 5 activists and 4 constitutionalist judges. But somehow they managed to get one of the activist judges, and not just an ordinary, sort of run-of-the-mill activist, but a strident activist, someone who's right in the thick of race hustling and gender quotas and race quotas, someone who's right at the apex, right at the cutting edge of activism. They managed to find that judge to hear the case. Now, I don't believe that's natural. I don't believe that's organic at all. I believe that they hunted around for a district and they go, that guy. Now, that's, again, not the way it's meant to work. And as I understand it, the judge finished the case early just so they could be moved on to this case. So it's obviously prearranged days, if not weeks in advance. This is the place where we'll have it heard. So it's judge shopping in effect. This is a place where I'll have it heard. This is the judge we want to hear it, and we know he's going to make it. Now, whether that decision is made by prearranged meetings and discussions, which would be very disturbing if it is, although I wouldn't rule that out. I couldn't prove it one way or another, by the way, but or is it just they know the sensibilities of this particular activist judge, and they know the judge will make the decision in the way they want it made, which indeed it was. The activist judge throws the case. No, you're going to go to trial, buddy, on this on this case that is like a huge stretch and should have been dismissed. Now, the only way they're going to get a conviction in this case is if they have another activist judge hearing it. So wouldn't be surprised if that's already in the works. And we need every citizen in the West, every citizen needs to be desperately concerned about this activist judge thing. Because at the moment, if you're a leftist or a globalist, those judges are making decisions that you approve of. But the day will come, whether it's tomorrow or next year, the day will come when they'll start making decisions you don't approve of, and they'll be taking away your rights and your property and your liberties. And you're going to look sideways on the wrong day, and you're going to be arbitrarily arrested. You're going to be arbitrarily brought before an activist judge, and you're going to be arbitrarily thrown in prison. Now, if you want that, then fine, have this activist judicial activity going on, and activist judges appointed. Don't clap and cheer when a screaming left-wing straight white male hating lesbian is appointed judge. Do not applaud that. Do not applaud it, because one day when a different sort of judge is going to sit there, and you're going to come along and they're going to say, "No, prison for you." Why? I haven't done anything wrong. You just got the wrong politics, buddy. Too fucking bad. And you don't want that. So you want facts, you want evidence, you want absolute impartiality. And that is the only way you and the people at the side of you and the people on the other side of the street or on the next hand, that is the only way you can be protected. Well, decisions will be made you don't like, for sure, but that is the maximum protection of your liberties as a citizen, and you want that, and always come back to that. So anyway, coming to the other side of the thing now, there's a Republican who's alleging election interference, and they've got a pretty strong case. There were many events that occurred only on the day of voting that didn't occur at any other time. They were disproportionately, in fact, they're nearly all in areas that were likely to produce Republican majorities and so on. So this case goes to court. Now, whereas in the other case, the judge put a very, very, very low bar to proving intent. Effectively, if the accusers say it's intent, the judge said, if that's it, okay, you've said it's intent, it's intent. And so the bar is very low. Effectively, an accusation is enough. And that's how low the bar is there. Now you go on the other side where the judge um, accepts the claims by the other side. It was just an accident. Just things went wrong on that day. Could have happened to anybody. Hey, no problem, no problem. So and again, this is something that would have drastically altered the election outcome. And so the judge then goes, okay, well, that we'll just write that off as incompetence or having a bad day. I'm not even really going to look at that. Now you have to prove intent. Now the other side can claim, it's just incompetence, and ineptitude's not illegal. I think negligence is, and I would argue negligence is criminal, but that's only my view. So the judge then holds the people making complaints against the Democrats in this case, puts the evidence bar very high. I mean, incredibly high. I don't perceive how it's possible to put the evidence bar that high, and when the other side wants the thing thrown out, because the evidence bar is set so high, the activist, again, another activist judge somehow manages to hear the case in a place where there's not that many activist judges. So out of I think the 9 judges on that court, there's only 2 you'd say would be activists, 7. Somehow an activist judge gets to hear it. Now, again, that's got to be a prearranged thing. And so the judge gets, the case gets thrown out because the evidence bar is so high. Now, this is not how a justice system works. The evidence bar must be about the same for both parties. That's called due legal process. Your evidence carries as much, tested evidence carries as much weight as the other guys does, or the other litigants does. And that's what's called due legal process. So we're seeing a vicious assault on due legal process all across the Western world, which just magically happens to suit the globalist agenda. Now, I'll use just to draw some parallels here that I saw years ago in the divorce courts, where this is pretty much the exact same case, and how differently the courts deal with it. Now, this is a case where the mother argues that the father during contact or visitations, I think it's called in America, contact with the children, weekends with the kids, that sort of thing, that he's always bringing the kids back late. So he's supposed to bring the kid, or is there some sort of just verbal agreement? He brings the kids back at 4 o'clock, for example, 4 o'clock on Sunday, but they're actually not getting back till 5:30. Now, the mother's agitating here that because he either because he drops them back late, that it's an imposition on her that's outrageous, not acceptable, and so on. So it comes before the judge, and the judge is viewing the straight white male with he's got full agency, he's responsible, he should be responsible, he must behave, we must control the straight white male, the evil straight white male. Whereas the poor put upon woman, who's white and straight, by the way, the poor put upon woman, she's the victim, she's an oppressed class, she has no agency. It's not, she doesn't have to live up to any standard or meet or adhere to any standard or behave within the law. That's not relevant. It's him, he has to behave. And so the judge just casually orders that he has to, she's meant to drop the children off for contact. She's late for that, but that doesn't matter. And so his arguments, well, look, she's always late, so why am I being singled out? Because you're a fucking Nazi. And so he has to, now the judge orders, well, you have to go and pick the kids up, and you have to drop them off, and you have to do it with sort of like a half-hour window either side, or you'll be back in court, and I'll be slapping you with some fines and whatever, loss of contact or something like that with the children. So he's threatened and finger wagged and verbaled by the activist judge. So he's fully accountable for it. Her arriving late with the children, nah, doesn't matter. So now, looking at the same case where it's the reverse, where she at the last minute is avoiding letting him see the children. She's not feeling well, or they're not feeling well, or so, she's running serious obstruction here. It's quite obvious. And so he's taken the matter to court. and but the judge could not be less sympathetic. And the burden of proof, the difference of the burden of proof in due legal process is completely chalk and cheese. So the guy's got it cold. He's got recordings. He's got video. He's got he's got it nailed. I mean, he's prepared the case well, and the judge can only make one decision, which is in his favour. But this is an activist court with an activist judge who's making decisions along ideological lines, not legal lines. So the judge listens to it or realises he has to find in favour of the guy. So the judge just casually says, "Well, the real reason you've obstructed, the father having time with the children is because you suspect he's been horribly abusing them. Isn't that right, Mrs. Smith?" And Mrs. Smith looks at the judge sort of rather blankly, sort of, "What the fuck's he talking about? Isn't that the reason, though? Because if you don't say that's the reason, I'll have to find against you. But if you say that is the reason that you obstructed conduct because he's a fucking Nazi fucking abuser, Hitler, then I will find in your favour and against him." So you're saying he's an abuser, aren't you? So the woman, still a little bit bewildered, nods to the judge. "Yep, that's it, done. So, Mr. Smith, Billy Bob, you're a damn fucking child abusing Nazi, and your visitation is now cut down to 1/2 day a month. And by the way, you're paying all legal fees. You're lucky I'm not putting you in prison." And that was so. That was the difference. Now the same case. But ideological activism, it's okay when we do it, and this sort of stuff. And those are the different. Now these are the different standards being applied to this when the Democrat complains or when the Republican complains. Two completely different standards of justice, and where in one case it's very compelling, the evidence is overwhelming in favour of the Republican, but it's still dismissed by an activist judge. Whereas in the case where the Democrat is complaining on an incredibly long stretch and very broad interpretation of the law, the judge still finds in their favour and against the other side. So again, this is the great tragedy of politicising the justice system, and this is the consequences. We'll be paying dearly for this all across our social structures for many decades to come. And just have a look at the nominees that the judicial nominees that the Biden administration puts up. I mean, we're talking affirmative action on triple steroids and it's, I mean, some of these people wouldn't employ them to sweep the fucking floor, let alone sit as judges. Now, and the way they talk, I mean, many of the women that they put up talk like first-year sociology students with that funny, whiny, rising terminal voice, that they put on, sound like Valley Tootie, snotty Valley girls, and these people get put up. And I'm listening to the questioning that they get. There's a lot of videos online about it, and I can't believe that anybody would have the hide to put up such low quality candidates. Now, somebody said, well, it doesn't mean that all judges have always ever been throughout time geniuses or legal scholars of the first order. And that's true, by the way. And I do know quite a lot of judges and lawyers and so on, so trial lawyers and whatnot, and often have had gone to functions where I think I'm the only person that's not a lawyer or a judge. So I've met these people up close, and some of them aren't very impressive. Some of them are activists, increasingly so for the younger ones coming through, but who are all pro-globalist activists, by the way. Are you against mass migration, you damn Nazi? But the older judges, again, not all of whom are geniuses, by the way, they believed in the law. The law had meaning, not ideology, not who's the victim or not victim Olympics or anything like that, but the law, facts, tested evidence. Decisions must be made on the law and the tested evidence. And so even if they weren't very bright, some of them weren't, even if they weren't very bright, they believed in that and believed that was the only way that they were to discharge their duties in the court, hearing cases and making judgments, and that to me was that is a huge safeguard against the tyranny of the state. And as long as due legal process is in fully intact, as it was with those judges, not that they were perfect, they were still human, they'd still make mistakes, but the fact they believed in the law and facts and evidence and tested evidence, that sort of thing, it's the biggest protection against tyranny that any society can have. And we must see it as that way. And if we don't, as a society, and we allow the continued infiltration of activists into the judicial system, then as night follows day, tyranny will follow. You've been with Tasteless today, your Pushback channel, and thank you for listening.